Καλησπέρα σε όλους, καλησπέρα από την Αθήνα.
Good afternoon, ladies and gentlemen. Good afternoon from Athens, from Brussels, from Cologne, the Konrad-Adenauer-Stiftung from Greece, and Cyprus, e-Kyklos and the Center of International and European Economic Law organized today's event entitled Rule of Law in the EU, Challenges and Perspectives. And of course, this is a quite topical issue at the European level and international level, and we do have distinguished guests tonight to discuss. I don't mean to delay any further, so I would like to give the floor right away to Henri Bohnet, Director at Konrad-Adenauer-Stiftung, Greece and Cyprus Office. You have the floor, sir.
Thank you very much. Dear Madam President, distinguished speakers, ladies and gentlemen, dear listeners and friends of the Adenauer Foundation, it is a great pleasure and honor for us as the Adenauer Foundation in Athens to host today's forum on challenges and perspectives to the rule of law in Europe. As we enter the second year of the global pandemic, we come to realize that our life, our society, our country will not be the same anymore than it used to be, even when we will get the coronavirus under control. In both the good and the bad sense of the world has turned and it has affected each one of us, as it has also affected our state, our country we live in, and how it operates. Digitalization, remote schooling and working, the health tracing apps and data protection, restrictions on the freedom of movement of all of us, and the growing dominance of privately controlled social networks. As we see, the rule of law is challenged in many new ways, and this is a major challenge for all of us. I am very pleased that today we have a look at these challenges and perspectives from different angles, from the European angle in Brussels, from Germany, but of course also from the Greek point of view. With the help of such outstanding speakers as Commissioner Schinas, Professor Venizelos, Professor Skouris and Professor Nussberger, it is a great pleasure to have you all on the forum. This is what CAS stands for, to bring minds and opinions together, to move forward and find good real solutions. I am deeply grateful to our partners from Evangelos Venizelos and e-Kyklos and for Professor Skouris and his institute, as well as to Elena Varvitsiotti for our moderator, and to Eleftherios Petropoulos, my colleague who has made it all possible, and of course also to our translators. It is a great honor that, Madam President, you are supporting our event today, and I'm very much looking forward to the discussion. Thank you.
Thank you very much, Mr. Bohnet. It is indeed an honor for us to have Her Excellency, the President of the Hellenic Republic, Mrs. Katerina Sakellaropoulou, who will also make some introductory remarks. Madam President, you have the floor. Thank you very much. I am so pleased to be here among friends. We have been deprived of this communication over the past thing. Now, the rule of law in the European Union is indeed an issue which has raised concerns over the past years due to various issues. And now, because of the pandemic, we have an additional dimension to address. So I am looking forward to the discussion that will follow. There are fundamental concepts and principles that today sound self-evident, robust, and indisputable in today's legal culture. In the second half of the 20th century and the sequel of the traumatic experience of the two world wars, constitutional democracy is flourishing based on the protection of our human rights and the review of law constitutionality. No one challenges anymore the regulatory quality and the power of European treaties and national constitutions. And of course, law does not mean the principle of the might is right, nor the uncritical and unlimited prevailing of the majority over the minority. It goes beyond political expediency and the conjuncture, and of course establishes universal dignity and the independence of individuals. So the rule of law is also the policy of counterweight, envisages democratic counterweight and institutional prerequisites enforcing general interests. However, over the past 2 decades, many of the sentences and assumptions of the previous century were challenged. Many of the expectations we had were disappointed. The world financial crisis widened inequalities, gave rise to political turmoil and social reorganization. It has seriously affected our political system, as of course also the confidence in European perspective, in the European prospect and its ideals. The migration and refugee emergency, the human drama along our borders has divided our union, has put European solidarity to the test. And so disintegrative tendencies have emerged, and latent conflicts between member states in the sector of humanitarian policy, which cannot be politically instrumentalized, but in fact requires shared stance and handling. And so terrorist attacks in Europe menace our way of life and the political organization. They raise the issue of security and alignment of security with liberty, with freedom. There are many urgent and imperative challenges for Europe. And today, amidst this COVID-19 crisis, the major stake is to manage to strike a very difficult and challenging balance between health, which is the overriding priority, and of course the protection of our rights and the preemption of another economic recession. These severe crises, which are interdependent, affect the rule of law and the liberal democracy. In countries with weak democratic foundation, populism erodes the representative institutions in the name of charismatic legitimation. But democracy does not exhaust itself in the free elections, and it is rather a perpetual claim for a free and responsible will of the people, equality, deterrence and prevention of arbitrariness in power. The independence of the judiciary and media pluralism constitute institutional safeguards for the free shaping of the will of the people, and of course, accountability of who rules. This is why, besides, they are targeted by the regimes which are called illiberal democracies. For the first time ever, there was an issue of compliance of member states of the European Union with the rule of law, and the procedures envisaged by Article 7 of the Treaty on the European Union were activated. The European Union has repeatedly expressed its serious concerns about the ongoing negative developments in Turkey when it comes to the rule of law, the fundamental rights, the freedom of expression, and the judiciary. And of course, this widespread tension conceals at the end of the day the very challenging of European awareness. The crisis Europe is going through are a breeding ground for Euroscepticism and the opposition to its fundamental values and principles. Historical and political time is going by at a higher pace than probably the traditional institution of the Europe may withstand. Economy, healthcare, social cohesion seem fragile, while the time of stability is long gone. History, besides, is not linear, but rather conceals surprises and disruptions. Notwithstanding, the European social rule of law is yet the more powerful refuge we have and a weapon against the uncertainties of our times. Europe still is a privileged part of this world. So against the backdrop of globalization and digital transformation of societies, where the networks of politics, political, cultural, and interpersonal communication and interaction prevail, isolationism and introversion are a confession of weakness rather than a display of force. So how to couple national identity with cultural diversity, development and growth with the protection of the environment, and contrast the climate change, as well as the prevention of new healthcare and fiscal emergencies, are all issues that are at the center of our attention. And of course, these are global challenges for global policies needed that go beyond European borders and cannot be designed out of the canvas of our European identity and our value wealth, that is freedom, equality, solidarity, and all those safeguards which have always constituted the European specificity, well understood. Unless we deepen this European integration, we will not come up with answers to the challenges of the future. Thank you very much. Well, I wish you all the best. Thank you very much, Madam President. I believe that the rule of law stands at the very core of our democracy, of our life. It is something we are proud of our European way of life, which makes a difference between us and our neighbors. But is it what we're talking about over the past months? We have seen compromises at the European level with Poland, Hungary. We have seen that the rule of law has been sacrificed for the European recovery. And now other issues are raised, are emerging, and the citizens all around the European Union have to cope with unprecedented situations, the restriction of freedoms and so on and so forth, or even the provision of personal data to companies, or even conspiracy theories that erode the credibility of even the European Union. In particular, in our country, we can see the unraveling of sexual abuse cases that probably have no precedent. So we have many interesting issues that hopefully we will manage to touch upon thanks to the distinguished guests that I will introduce right away. We have Margaritis, Schinas, Vice President of the European Commission, responsible for promoting the European way of life, including the rule of law. So it's a great honor to have you here, sir. We have Angelika Newsberger, former Vice President of the European Court of Human Rights and a professor in Constitutional, Public, International and Comparative Law at the University of Cologne. We have Vasileios Kouris, a former President at the Court of Justice of the European Union and President at the Center of International European Economic Law, Professor Emeritus in Public Law, and Evangelos Venizelos, Professor in Constitutional Law, former Deputy Prime Minister and former Minister of Foreign Affairs, amongst other things. I am today's moderator. I am a journalist at Katerina. I am Eleni Varvitsioti. And for those who are watching this event, I would like to encourage you sending your questions and sending us, of course, your messages during this interesting discussion. I would like to give the floor to Mr. Schinas. Each and every one of you have approximately 15 minutes for a first approach, for some first remarks. Thank you very much. Thank you very much, ladies and gentlemen. It is a great honor for me to follow Her Excellency, the President of the Hellenic Republic. I am delighted to participate in this panel with two people whom I owe much. I am grateful for because they taught me the law, administrative law by Mr. Kouris, and constitutional law by Mr. Venizelos. So some decades later, I would like to publicly thank both of you. Now, today, what we are to touch upon is at the heart of the European way of life. Indeed, the European framework for rule of law is essentially the convergence of our common values, and our common values are the very foundation on which European Union was built. It goes without saying that Article 2 of the treaty describes eloquently what indeed shapes the political culture, political civilization of a united Europe. As our founding fathers, envisaged it, including dignity, freedom, equality, the rule of law, the respect of fundamental rights, including the right of minorities, of course. In other words, the rule of law constitutes what our dear friends Anglo-Saxons describe as the diamond on the crown of Europe. So this is the very foundation on which European societies have been shaped. And they are a model, a role model for the remaining countries of the world. Non-discrimination, justice, solidarity, mutual trust, and equality before the law, gender equality. The rule of law is the one that guarantees that all public authorities operate within the restrictions and constraints set by the law. So the respect of the rule of law is a conditio sine qua non for the operation of the European Union. This unprecedented cooperation venture among free countries. Despite our member states have different national and sometimes even political identities and preferences, legal orders, traditions, the very essence of the rule of law is the same throughout the Union. It is a common denominator which cannot be compromised, cannot be negotiated. And certainly, Mrs. Varviciotti, it cannot be sacrificed for the sake of other priorities. It guarantees, it ensures all European citizens equality before the law and safeguarding of their rights. It is vital, the rule of law is vital for the enforcement of the law of the European Union to build mutual confidence between the member states, because it constitutes the foundation for the cooperation between the member states institutions with reference to issues that have to do with the civil and criminal law. For example, if the courts of a member state do not operate independently, there's a risk for the trust in efficient enforcement of law to be challenged. So problems when it comes to the operation of rule of law in a member state are a problem for all member states. And the wide reading of the concept of rule of law, the content of rule of law is this, that this is not a problem of some or of a few people. It is something that concerns us all. And it is not by accident that I'm saying that. It is internationally recognized that the European Union has high standards regulating vital sectors, as for example, the independence of the judiciary, active civil society, pluralism, media pluralism. However, let us be frank, when it comes to implementation, these high standards are not implemented and enforced correctly at the same level everywhere. Recently, some issues have been raised about the compliance with rule of law in specific member states. The reforms in the sector of the legal system in Poland has been a source of major controversy, and serious concerns persist when it comes to the independence operation of a Polish court. In Hungary, we have a certain specific problems when it comes to the respect of rule of law, when it comes to the organization of civil society, freedom of mass media, and the rights of migrants and asylum seekers. I know very well that Mr. President Skouris will make specific reference to these issues. From a political point of view, though, these cases show that there is a clear risk of regressing. That in Greece, in Europe, we cannot sit by our rulers, and we should not give the enforcement of rule of law for granted. And I would like this to be my central message to those who are attending tonight. The rule of law is not a vague and abstract principle, but it is not also a juxtaposition of words. It is not theory. It is synonym to action and responsibility. These are not just principles and words, but it is the responsibility of actions we are talking about. So safeguarding rule of law is a shared responsibility of all institutions of the European Union and all the member states of the European Union. And each and every one of us have to play the role that competes to us. The European Commission, I am honored to participate in, under the guidance of the President von der Leyen, has very clearly set our intentions when it comes to rule of law. We have bluntly and clearly said that we will activate any means, have any weapons we have in order to safeguard rule of law in the quest of the new Union. Over the past year, we gave this political objection a specific content, creating the rule of law mechanism that is based on an annual report. This is a really unprecedented and innovative mechanism in order to abide by the rule of law in a preemptive way, with a view to promoting the rule of law before the problems emerge. The first report was adopted last December, and that was the offspring of thorough discussions and close with all member states and close cooperation with the national authorities and institutions. The findings of this first report were encouraging, and hopefully the method itself shall contribute to the annual improvement of performance, because it will act as a catalyst in highlighting and rectifying any problems, which goes for Greece, for our country, of course. The report recognizes that Greece has adopted a significant set of reforms of the judiciary, and over the past years, Her Excellency the President of the Hellenic Republic was actively involved in her previous capacity in this reform, but of course it does not mean there's not room for improvement when it comes to digitalization, for example, and the acceleration of the procedures in justice. And of course, this is not a punitive approach. Our objective is to have a well-documented picture of the situation throughout Europe in order to allow the member states, with the support of the European Commission, to plan in due time the necessary reforms for the best possible operation of the rule of law in the sectors concerned. Of course, there are specific cases in which this willingness to cooperate does not exist. For example, where there's a systematic threat against the independence of justice, the Commission intends to activate the infringement provision for a violation of the real justice independent and the right to lodge an action. So the concerns in Poland has made the Commission to activate the procedure under Article 7 of the treaty in December 2017, and a similar procedure was launched by the European Parliament for Hungary in the year 2018. These steps are unprecedented in the history of the European Union. They show that the rule of law is one of the core values of ours, and it also shows that the European Union is mature enough to activate all the mechanisms and means available to safeguard our common values. You'll know that the procedure under Article 7 of the treaty is an extraordinary procedure. Many have argued of it as being the button of a nuclear weapon. But it is by far the most efficient and effective weapon we have in case of systematic and regular breaches of the rule of law in a member state. You know what the consequences are of when it comes to Article 7, and this is why the decisions taken by the Council are very demanding and challenging. But we should not underestimate the fact that a dialogue in the framework of these procedures with the member states has an inherent value of improvement. An equally important recent development, a new instrument in our struggle, has been safeguarding the rule of law with a new regulation for a general conditionality for the protection of the EU budget. Simply put, this regulation allows the protection of the budget in case the general deficiencies as regards the rule of law result which impact the sound management of European resources or even the general interests of the European Union in a direct way. These were agreed upon at the level of the European Council last July. And we have managed in conjunction with the European Parliament to have a European agreement, a European debate, and a European agreement that enriches the European instruments, yet another instrument, another tool to safeguard rule of law. By way of conclusion, I would like to also touch upon an important aspect, that is the protection of the rule of law apart beyond the European borders. So we firmly believe that this aspiration is strategic, for it may have a direct impact on the vital interests of the European foreign policy as stability, security, investment attracting, and of course, encouraging economic growth. I believe it goes without saying how important this targeting is for our neighborhood, that is the Balkans and Eastern Mediterranean and Northern Africa. We do not have illusions, of course. Sometimes the lack of a real political will is more than visible, especially when it comes to the independence of justice without interventions. So our future endeavors need to continue to go along the path of an approach that wishes to change, to disrupt these practices, especially in the countries in the wider area with which we have close commercial and other relations. And this may be done through assessing timetables and specific actions that will allow us to measure the results of this improvement in tangible ways. I would like to conclude by saying that at the end of the day, the rule of law is the main parameter that separates the democratic societies with other authoritarian regimes. Our union has experienced a deep trauma of the rule of law erosion. And we all know that this erosion does not happen overnight, but it is rather gradual. And we here in Europe have the sad privilege of having experienced in the past century the result, the outcome of the erosion of the rule of law. The first time in Sommern and Ypres, and the second time in Auschwitz in the concentration camps. So because we know, because we have full awareness, we will never allow similar phenomena to hinder the road to integration. Thank you very much, Vice President. Certainly, we will have the opportunity to answer many questions later. And now I would like to give the floor to Angelika Nussberger, former Vice President at the European Court of Human Rights and Professor in Constitutional, Public, International, and Comparative Law in Cologne. You have the floor, Madam.
Thank you very much, and thank you for inviting me far north in Cologne to come together with you in our virtual meeting. Well, first we may ask, why do we discuss rule of law in the year 2021? It should be a stable ground on which we are standing and where we have no doubts that it's stable and that it's our European ground. But as Mr. Schinas has already mentioned, there are issues to discuss, and it's not only nice things that we can say that we all agree what rule of law is. So what are the challenges? I would see basically two challenges. One is that rule of law is a very broad notion, and we have all our different heritage that we take together in this notion. You mentioned already the British approach to rule of law coming from Germany. We have the idea of the Rechtsstaat, which is a bit different, but not completely, but it's parallel, but it's not exactly the same. We all come with our traditions, and when we have such a nice notion like rule of law, there is a danger that it's something like a catch-all provision, and in the end it's all and nothing, and we don't really know how to use it. That's the first challenge. And the second one is even more difficult. It's that by now we have experienced that we interpret rule of law in very different ways. And that is quite a recent phenomenon, and my colleague has already mentioned Poland and Hungary. And to make it clear what we are talking about, I just have collected some quotations that are indeed provocative, I think. I have some quotations taken out of a book dedicated to the Venice Commission. The Venice Commission is now in existence for 30 years, and for this anniversary, a book, Liber Amicorum, was written for the Venice Commission, and there all the members published their articles. And there I found the article of the Hungarian member, András Varga, who is by now, starting from 2001, also the president of the Curia in Hungary. And he wrote an article named Rule of Law and Constitutional Identities, Concurring or Complementary European Values. And let me just quote to show how different you can approach rule of law. The first literal quote is the following: the democratically elected governments by their signature and the democratically elected parliaments by their ratification express clearly the will that the EU and its institutions should accept the jurisdictions of the European Court of Human Rights. But the European Court of Justice has categorically blocked this. What else does it mean if not that democracy is suppressed by the rule of law, interpreted arbitrarily by a too powerful court? End of quotation. Second quotation taken out of the same article: when the rule of law or human rights are instrumentalized and used as weapons in political debates, these values are transformed from common ideals to sectarian idols. Thus, Strasbourg or Brussels or Luxembourg may become a blasphemy for other political movements. End of quotation. And the third quotation, once again out of the same text: but if there is no instrument to correct misguided judgments, if there is no counterbalance to unlimited power of international courts that expropriate legislation, if constitutional courts are mere servants of international courts, we face arbitrariness. I think these are quotations that we can interpret as a sort of battle cry. It's something quite different from what we normally understand by rule of law. It's making an opposition between democracy and rule of law, and also taking up the fight about the last word between constitutional courts and European courts within this notion. Let me add a few other quotations by the Venice Commission. And there, now this was one of the countries that is problematic, that is Hungary. Now quotations about Poland. I want to quote, and I think my colleague has already mentioned, the reforms of the judiciary in Poland, that they are problematic. There is an especially problematic reform of the Judicial Council, and you have mentioned the procedure that is going on in the EU. The Venice Commission is very clear about what it thinks this reform is, and let me just quote a few words of this opinion of 2014, where it says, In one respect, the proposed system, so the introduction of a new judicial council, is even worse than its Soviet predecessor. The draft act of this new law introduces a system of extraordinary review for the future judgments, which is problematic by itself. In addition, the draft act provides for the reversal of old judgments, which at the moment of their adoption were final and were not subject to any further review. This is not quite a retroactive application of criminal law, but in practical terms, it may have a similar effect. And then it says this poses serious risks. It talks about serious risks of the independence of all parts of the judiciary in Poland. So I think the problem is really quite clear. We have a common heritage. We are proud of this common heritage. We build everything on this common heritage. And at the same time, we have a fundamental dissent of what our core values mean. I think my predecessor, he even used the word trauma. It's traumatizing that rule of law is breaking away or is not so, there is no longer such a consensus as we want to have. And just to quote the EU Commission, which talks that the confidence of all EU citizens and national authorities in the functioning of the rule of law is particularly vital for the further development of the EU into an area of freedom, security, and justice without internal frontiers. So this is where we are, and I think we were, to a certain extent, unprepared to such a clash of visions of rule of law in Europe, because we thought the accession process was a real success story and we didn't expect a political turnaround in some of the member states. I think the reaction to this challenge is difficult for two reasons. And one is the lack of procedures. So just to quote the EU Commission, which talks about the necessity of finding ad hoc solutions, since current EU mechanisms and procedures have not always been appropriate in ensuring an effective and timely response to the threats of rule of law. And my predecessor has just mentioned the reports that were set up. It's a new way of reacting. So the procedure, the lack of procedure is one challenge, and the other challenge is this lack of consensus, and we have to come back to find a consensus. So the title of today's discussion is twofold. It's about challenges and perspectives. So let me say a few words. Where can we go from there? We are optimists. We want to build bridges. Concerning the contents of rule of law, I think a lot of work has been done to fill this open notion with a clear content. The Commission has clearly said in 2014 it is legality, which implies a transparent, accountable, democratic and pluralistic process of enacting laws. It's legal certainty, prohibition of arbitrariness of the executive powers, independent and impartial courts, effective judicial review, including respect for fundamental rights, and equality before the law. So we do have a core concept that we can easily define. What is very helpful is the work of the Venice Commission. The Venice Commission has built up a rule of law checklist. So just in order not to be vague, but to be very concrete and to provide a tool for assessing questions of rule of law, they have set up benchmarks and checkpoints, and this is used by the Commission as well. Just to give you an example, we are now talking about the pandemic in quite a few countries. We have, according to these emergency situations, we have specific reactions. And this rule of law checklist provides concrete questions how we can assess if rule of law is upheld in a situation of emergency. And these are questions like, are there specific national provisions applicable to emergency situations? Are derogations to human rights possible? And is a derogation prohibited for certain rights? And are the derogations proportionate? and are they limited in duration, circumstances, and scope? What is the procedure for determining an emergency situation, and are there parliamentary control and judicial review possibilities in such a situation? So on a level even going beyond EU state, the Venice Commission has elaborated a rule of law checklist that is a workable tool for assessing what is happening in the different states. So Venice Commission is one actor. The Commission, EU Commission, has already been mentioned as a very important actor with the annual reports. And then we also have the courts. We have the European Court of Justice, and I think my colleagues will talk about that. So I just say a few words about the European Court of Human Rights. Rule of law is a red thread going through the jurisprudence of the court. And just to give you examples about cases concerning independence of the judiciary, we have quite a lot of cases about independence of the judiciary having been solved by the court, and then the principles have been taken up also by Luxembourg and by Brussels and by the Venice Commission. Just one case is, for example, Baca, the former Supreme Court president of Hungary, who lost his job as a president because of the new constitution, and that was seen as a punishment for his opinions. And the European Court elaborated standards for not punishing judges for the opinions they say. And just today, for example, the European Court of Human Rights has referred the case about the dismissal of the members of the Judicial Council in Poland to the Grand Chamber in order to deal with it immediately on the level of the Grand Chamber with 17 judges. The European Court of Justice has worked mainly on the basis now of Article 19, paragraph 1, and has found a possibility of reacting to what is happening in Europe in this way. And it's I think we can already say it's building up a permanent jurisprudence on the basis of Article 19. So where are we now? I think we have to face the fact that the crisis has not yet been solved, but I would say there are reasons for optimism. So in my view, the institutions are working well. They use a clear language to address problems. That is done in the reports mentioned before. That is done in the opinions of the Venice Commission that I have mentioned. I think the European institutions, Council of Europe, EU, they cooperate in order to strengthen one another. And also we have to see that even in countries where we have difficulties right now, at least half of the population is in favor of staying within the rule of law situation that we were used to have before. In my view, it's necessary to take all these questions really seriously. We have to admit that there is a necessity to accept that there are different approaches. And in the end, I think it's better to convince and not to condemn, and to come together in this way. Thank you very much.
Thank you so much for this very interesting presentation. Now let me give the floor to Mr. Skouris, who is President of the Center for International European Economic Law, former President of the Court of Justice of the European Union, and Professor Emeritus in Public Law. Let me remind you, to all attendees, that you may send any question, you might like to be responded by the speakers through Facebook and YouTube. Mr. Skouris, you have the floor. Thank you so much, Mrs. Vavitsiotti. Thank you indeed. I will start with a very recent development. The Polish Minister of Justice, who has also the tasks of a public prosecutor, addressed the highly flawed constitutional court of his country and asked from that to declare, contrary to the Polish constitution, the regulation 2020/2092 of the European Parliament and the Council on the general eligibility status on the protection of the budget of the Union. It's about the regulation through which, after many efforts and recriminations within the European Council, we define the rules that are necessary for the protection of the budget of the EU in case of violating the principle of rule of law in the member states. This action creates a series of objections. First, it's a paradox that the minister goes against a measure as being against the constitution, which was voted and approved by Poland as member of the Council in the framework of the EU. Second, it is absurd to ask and debate about how we can declare as opposite to a national constitution of a union legislation, because such a competency goes beyond the logic of the institutions in the member states. Third, this activity by the minister breaches the paramount obligations of Poland emanating from the EU legislation and from the participation of the country itself into the EU. So, we can see that it is imposed an action of the Commission against Poland before the court when we take into account the minister has committed a repeated offense, as it's not the first time that we are activating the Constitutional Court against activities coming from EU institutions. Fourth, if Poland believes that the regulation in question contradicts the primary EU legislation, including the Charter of Fundamental Rights of the EU, it has the right, and of course, in spite of the fact that this has been voted by the Council, to have an action for annulment before the ECJ, which has the sole competency to annul some articles of the EU legislation. If this is valid, if what I just mentioned is valid, how can we explain such a serious lapse by the Polish Minister of Justice? It is true, and of course this has already been mentioned, that problems directly linked to what we call rule of law may appear quite often during the last 6 years in specific member states, especially in Poland and Hungary. The governments in these two countries have had some drastic interventions, mainly in the organization and operation of justice, starting from the constitutional courts, which composition was altered and the operation of those became more difficult so that they can be more friendly towards the government, continuing with ordinary courts so that the judges could be under the government's control through the replacement of the big number of judges through the method of the obligatory retirement, as well as through the creation of draconian sanctions, or the fact that we raise some judicial material. In the forefront, we can see Poland, where the executionary power has new measures to undermine justice and limit down its independence. A second sector of activation for these over-conservative regimes are the mass media, through voting laws that hinder the operation and limit down systematically the multiple voices to be heard, contradicting Article 11 of CFR, according to which the freedom of mass media and pluralism should be respected. Taking into account this unpleasant situation, I would try to express in a nutshell the possible sanctions relating to the EU legislation, which may be imposed into whatever member states is violating the guarantees of the rule of law. To be safer and more clear what we mean by rule of law, I will refer you, without any other comments, to the definition of this article of the regulation 2020/2092, which was alluded to before by my colleague, Mrs. Nürnberg. The rule of law includes the principle of legality, which means a transparent and accountable, democratic and pluralistic lawmaking procedure, the principle of legal certainty, the ban of the arbitrary exercise of executive power, the effective judicial protection, including access to justice by independent and impartial courts for the distinction of powers, as well as the banning of any discrimination and equality before the law. Some two main types of sanctions are stipulated in the primary EU law that was mentioned by Mr. Schinas as well, Article 7 of the TEU, and the second in Articles 258 up to 260 of TFEU. Let me here clarify from scratch that I'm talking about legal and not mainly political or diplomatic sanctions which can be faced by the states that cause a trauma to the institution of the rule of law. Moreover, I leave aside, for the time being, the different regulations of these regulations. So through Article 7, there is a complicated and quite heavy mechanism that evolves into many layers, starting from the Council. It then refers to the European Council to end up again to the Council. It presupposes unanimity on the one hand, and on the other hand, some powerful majority at the level of the EU in order for the Council to take a decision through which we can suspend some rights of the respondent member states, including the right to vote for the reps of these member states to the Council. It is obvious that the ones who wrote the treaties wanted to put some safety valves that will make it less drastic, because apart from the different balances at the level of the highest institutions, it is stipulated that for its decision, the Council is not limited to the issues of rule of law, but should take into account also possible consequences coming from this ban of the rights into the obligations of both legal and physical entities. The second sanction mechanism is more known, since the member state violating its obligations before the EU is facing an action before the European Court, and since we see that indeed there is this delinquency, this took place, it is condemned by the court and should abide by that, remedying the infringement. 2 points here of particular importance. The right to lead to justice this state, it belongs also to the other member states, regardless of whether they invoke a legitimate interest. But it's quite rare the use of this procedural possibility, opting for leaving that responsibility to the European Commission. Anyway, we must here stress that, especially when it comes to our issue, the Dutch Parliament, in its vast majority, demanded the government to lodge against Poland an action for breach the commitments coming from the rule of law. In the case that the member state denies or neglects to abide by this conviction of the court, there is a second proceeding, again upon the initiative of the Commission, in order for the member state to pay a lump sum or a penalty in money. In practice, we see the payment of a lump sum, and this is defined for a timeline for the issuing of the first sentence until the end of the second proceeding, whereas a sanction in money is defined for the timeline from the issuing of the second ruling until the full compliance of the member state with the content of the first one. There is already a case before the court on infringing the principle of rule of law. A critical question is to what extent these two types of sanctions have indeed been imposed until today, and what has been its efficacy. Starting from the procedure of Article 7, Mr. Schinas already mentioned the two cases where this procedure was initiated, but to the best of my knowledge, it doesn't seem that this has come to an end. Here, I should say, and I don't know, that there is no other attempt to implement Article 7 referring or invoking rule of law when it comes to the possibility to really impose harsh measures. The second sanctioning mechanism, that is actions for the infringement of the EU legislation, were not for a big timeline into the priorities of the Commission. However, on the one hand, the multiplier effect of the interventions in the independence of justice, and on the other hand, the delay in the progress of the procedure according to Article 7 of the treaty, raised awareness amongst the Commission and urged it to use the classical weapon of Article 258 of the TFEU against the member states that systemically violated the obligation to abide by the rule of law principles. Thus, there has been a series of convictions ruled by the court, especially against Poland, having as an object attacks against the independence of justice. I should here be frank and tell you that in a monograph that was published in 2018 in German, I expressed my preference to the action against a member state when the respect of the rule of law is established as of paramount importance for the EU. And I argued that Article 2 of the TEU, that unless the principal values on which is based our union, among which, of course, the rule of law, it shows, or rather, it might be an autonomous reason for action of the Commission and convict the disobedient member state. But I see that the Commission, without neglecting Article 2, shows a preference to specialize in infringement and avoids to use the wording of rule of law as a reason to refer the member state before the court. At this point, I would like to elaborate on in the framework of the overall efficacy and mechanisms on the rule of law. It is critical also to remind that the procedure of an action against a member state presents a big asset that we can ask for provisional measures, which happened in many cases after 2018 and had as a result for the court to order the suspension of law enforcement in Poland about the generous decrease of the limit age for the judges of the High Court. Last but not least, when it comes to this prevalence of the action against the member states versus the procedure of Article 7, the court itself agreed through a turn that its jurisprudence took in 2016 in the case of the judges of the Portuguese Court of Auditors that Mrs. Nussberg alluded to. We saw the importance of Article 19 of the TEU as a provision that supports the independence, which is a right based on the EU legislation by the judges of the national courts. The main argument here is that the judges of foreign member states might be in a position to interpret and implement the law of the EU in litigations that are pending before them. The Court of the European Union imposed the guarantees that emanate from that when it comes to the quality of the national courts emanating from Article 19, combined with Article 47 of the CFR on the effective judicial protection, without being interested in whether in that case the judge of the member state implements or not the EU rules. Likewise, we can see that from the EU legislation, there is an independent and comprehensive obligation of the member states to absolutely defend the independence of judges and abide by that which is up to the control mechanisms stipulated in the treaties. It is of paramount interest, the system of sanctions that is introduced by the most recent regulation 2020/2092, about which we have talked that much. Before I invoke the definition of the rule of law, and normally now I should deal with the system of sanctions stipulated by this regulation, which of course is a very important issue. But I will not do so for reasons of time. But since we're going to have the chance to discuss about this issue, when there will be the first results from the implementation of the regulation. So we have three categories of sanctions: the procedure of Article 7 of TEU, the action for infringement of obligation coming from the EU legislation, and the new mechanism under the regulation 2020/2092. Judging by the appropriateness of this measure, it's difficult to express ourselves about the regulation 2020, which has not yet been implemented. Amongst the remaining two sanctions, it seems that prevails the last, that is the action against the infringement of some aspects of the rule of law, and weakens the procedure of Article 7 due to the complexity that it has. Besides, Article 7 might allow for the for imposing serious measures, since we are talking about repealing rights of the accused state, but this procedure is difficult to finalize and it has a more political tone if we take into account that the final ruling of the Council can be challenged as a decision by an EU institution before the court, but it is not examined when it comes to its substantial legality, unless, or rather, but it is examined only when it comes to keeping the provisions of Article 7. The assessments of the EU institutions goes beyond the judicial control. Article 269 TFEU. It remains to see the classical action against a member state, which of course has given some fruits, but it cannot be considered as a panacea. Usually, upon Article 258 of the TFEU, we can see isolated cases of infringement of specific obligations on behalf of the member states, and not, as happens in Poland, systematic infringement in the organization and operation of the judiciary. The accumulation of convictions having as an object each one of the multiple offenses, or rather offensive behaviors of the Polish government, may decrease the dynamic of the court, which is invited to deal with any minor problem in the field of the judiciary, such as the compulsory transfer of police prosecutors from big cities to remote small regions. This means that in reality, a drastic measure to avoid systematic attacks against the rule of law does not exist right now. We're waiting for the activation of these mechanisms under the Regulation 2020/2092 in order to impose financial sanctions, which by definition are likely to make disobedient member states to be aligned with the obligations emanating from the rule of law. By way of conclusion, I believe that it's quite fair to mention that on lack of respect on rule of law, not only the member states are controlled, but also the institution of the EU, as happens with the compromise that we saw at the level of the EU Council when it comes to the Regulation 2020/2092. I had the opportunity to express myself in Katerina newspaper vis-a-vis the intervention of the European Council, about which the treaties explicitly stipulate that it is not a lawmaking institution, body, when it comes to shaping the regulation itself, as well as the guidelines that must be delivered by the Commission to facilitate its implementation. As if this was not enough, the European Council moved on a bit further, because on the one hand, it demands from the Commission not to implement the regulation before finalizing the guidelines and on its implication, and on the other hand, it forbids the Commission to finalize them for as long as there is an action for annulment pending against the regulation. In other words, could you please come to an end, because we are, yes, just 1 minute, Mr. Varvitsiotti. In other words, if Hungary and Poland materialize this threat, that is to have action against the regulation before the court, then in essence, there will be a temporary suspension of it, since the guidelines are a prerequisite for its implementation, but this cannot be issued if there is a lis pendens. Here, the need to achieve unanimity at the level of the European Council had a big price for the rule of law, which pays particular importance into the respect of the competences of all bodies. This is how we can explain the effort of the commissioner, of the minister rather, says the speaker, to talk about it and say that the Commission will gather some data for the real state of play in the member states. This is something encouraging. Thank you so much for your attention. Thank you so much, and apologies for the time frame. Thank you so much, Mr. Skouris, for the very detailed presentation. Let me straight away give the floor to Mr. Venizelos, Professor of Constitutional Law at University of Thessaloniki, former Deputy Minister of the Greek government, former Minister of Foreign Affairs, and former Minister of Justice. President, you have the floor.
Thank you very much, Mrs. Varvitsiotti. Thank you very much for moderating our discussion. I would like to warmly thank Her Excellency, the President of the Hellenic Republic, Mrs. Sakellaropoulou, for having honored us with her presence and with some introductory remarks, which were really precious and thorough. I am so delighted to have co-organized this event together with the Konrad-Adenauer-Stiftung and the Center for International and European Economic Law. And I am glad to have together with me the Vice President of the European Commission, the former Vice President at the European Court of Human Rights, and the former President at the Court of Justice of the European Union, the most ideal speakers, that is, in order to have a deep look into this important concept. So rule of law in the EU, and we are discussing that amidst a pandemic which is perpetually restraining and limiting our freedoms. And of course, given that our audience is not made up of lawyers, legal experts alone, we need to clarify that although in Europe there are three different traditions when it comes to the rule of law, that is the British one, the Anglo-Saxon rule of law, the German tradition of Rechtsstaat, and the French État de droit, or prééminence de droit. In Europe, we have ended up having a common denominator, which is ideally codified by the Council of Europe, the Venice Commission checklist, rule of law checklist. Now, what is the rule of law? Now, the rule of law is the liberal aspect of liberal democracy. European democracy, constitutional democracy is liberal, is liberal. If we take out the liberal aspect, that is the rule of law, if we take the rule of law out of democracy, then this democracy will collapse. Now, what are the ingredients of the rule of law? The subjecting the public authority to the prevailing of the law, especially the constitution. Legality check and control, the judicial review of the constitutionality of laws, the respect of fundamental rights and freedoms, safe law, the access to law, and being entitled to the right to fair proceedings, fair trials. Are these all factors respected in the European Union? Of course, yes. The rule of law is a conditio sine qua non for the European integration, according to the Article 2 of the Treaty on the European Union. It is an essential ingredient of European constitutionalism. It is a conditio sine qua non for constitutional democracy and a structural ingredient of the European legal culture. Notwithstanding, there is a twofold problem when it comes to the rule of law. I would like to stress there are two different two different kinds of crises in Europe. First, they politically declared differentiation of some member states, that is, their governments, and their majorities, of course, their parliamentary majorities, as against or vis-a-vis the European interpretation of the rule of law. So there are some member states or some governments that derogate from the European tradition, the European perception vis-a-vis the rule of law. And this is a political choice of which they are proud and which they connect to their national constitutional identity of Poland, of Hungary, and so on and so forth, and with their sovereignty at the end of the day. And there's a second category of problems pertaining to the rule of law that I would call the cross-cutting, the horizontal, the everyday issues pertaining to the rule of law. That is to say, the efficient operation of the rule of law safeguards throughout the member states under any circumstances. What is more, in these current circumstances of an emergency, of a pandemic, of a terrorist attack, or even of a financial recession, a financial crisis circumstances as the one we experienced between 2010 and 2019. Now, this issue is dealt with by the European Union, I believe, by targeting the first group of problems. That is to say, the European Commission and the European Court of Justice mainly focus on the major structural derogations of member states like Hungary, Poland, allow me to say even others, because now there are problems with Romania and Bulgaria as well, maybe also with other countries which insist on such an approach. And this is so because these member states talk about the separation of powers, justice and the judiciary independence. The European Union believes that national courts are European courts because they comply with the European law. So the European law needs to be enforced by courts which are also safeguarded. So in the name of its own legal orders, the European Union is in clash with these countries which actually violate the independence and which also hinder the media pluralism, the university pluralism. They have also other problems with corruption practices, widespread corruption practices, and certainly there is a common denominator that is national populism. So they do have a democracy deficit. I mean, the rule of law related problems are democracy related problems. Now, when it comes to the widespread rule of law problems, when it comes to the respect of rights, for example, where the perpetrator may be any country whatsoever, I would say that the main controller is the Council of Europe, and especially the European Court of Human Rights, or the Human Rights Commissioner of the Council of Europe, the Venice Commission, some way, because the European Union's mechanisms need to activate with reference to the enforcement of European law, of the community law. So there are some issues that are dealt with, especially with the mechanisms of the Council of Europe. Although, of course, there is a balance between the two institutions. And of course, there is a balance between the two European courts, the European Court of Human Rights and the European Court of Justice. There is a mutual respect and so on and so forth. Now, when it comes to the cross-cutting, to the widespread deficit of the rule of law, my view is the following. It's not a matter of what is happening now with the COVID-19 related restrictions on the right to assemble and the mask use and so on and so forth. I mean, the European Union has managed to deal with that, and hopefully we will get rid of problems thanks to mass vaccination. But the problem when it comes to rule of law, this will emerge in the aftermath of the pandemic. So a problem pertaining to the rule of law will emerge if the European Union and the Eurozone does not prove flexible enough with relation to economic governance and fiscal framework, especially. So when it comes to the fiscal deficit, the primary deficit, etc. So Europe as a society, as an economy, will not withstand all that in the aftermath of the health crisis and the economic recession. It will not withstand pressure stemming from its own fears pertaining to growth, development, employment, welfare state, pensions, the degree and level of income, and so on and so forth. This is extremely important. However, the other member states when it comes to the rule of law, they stress the European Union because they are majority democracies. So because they have the majority in their parliaments, they end up being illiberal democracies. Now the problem is, why is this happening in Poland and Hungary? Could we argue that this is a clash between the European West and the European East, similar to the one between the European North and the European South? Now, this is not easy to say, of course, because there are countries that have experienced the existing socialism experience and do not have the rule of law. I'm thinking of the Baltic countries or other countries like Slovenia and Croatia, the Czech Republic, which is also flirting with that. But anyway, what is the common denominator? Certainly, civilization and the cultural tradition, the legacy of existing socialism count and matters. However, I find that these are countries out of the Eurozone. They are not at the core of the Eurozone. So these are states that feel free to have their own monetary policy, which makes them feel able and entitled to be more brutal when implementing their policies. And they are also encouraged by the messages conveyed by big countries, as Germany, for example, with the latest judgment of the Constitutional Court for the ultra-virus control exercised on the name of the national identity. So they argue, if I can have recourse to ultra-virus, so to the exceeding of the European Union's jurisdiction, why in Poland am I not entitled to ask my constitutional court of saying that the regulation on conditionality for the protection of the European budget opposes the Polish constitution and therefore breaches national constitutional identity in Poland? Well, I will argue that, and then I can bargain. Because at the end of the day, what will be the consequences if I violate the regulation? Probably they will take away from me some of the financial resources. However, I will keep on being entitled to vote for another important European project. So I will not be deprived of the right to vote. So I will continue participate in the negotiations. So it's very difficult to enforce the sanctions of this conditionality on the states. So the problem here, in my view, is much more profound, and it pertains to the ideological, to the value approach between the rule of law, national identity, and national homogeneity, because those countries, those member states, at the same time raise a question of migrant and refugee flow management, they raise a question about vaccine management. It's not by accident that the Prime Minister of Hungary say, I don't trust the vaccination policy of the European Union because I need to safeguard the health of my citizens. And there is a plethora of other examples we could give. So the common denominator, in my view, is the failure to participate in the Eurozone, national populism, and the political investment in identity. This is an identity-related policy. This is the official negation of the principles of the rule of law, which means that Europe needs to give an inclusive answer, which will safeguard, on the one hand, the European democracy, the European rule of law, the European welfare social state, the development prospect, the sense of a struggle against disparities and inequalities, which is not easy to argue because indeed inequalities exist and they may be exacerbated in the aftermath of the pandemic. So we need a more thorough and more multifaceted approach to keep the European Union united on the foundation of its principles, of its values. And by saying so, I'm thinking of liberal democracy, democracy and the rule of law together. Thank you.
Let me please unmute yourself. Thank you. Apologies. I'm saying thank you, President, for this enlightening presentation. I would like to ask you, first of all, let me remind to all viewers that you can send your questions and get the answers. But I would like to ask first the Vice President, Mr. Schinas, and all the others, if you have an answer to that. We saw the EU context and we saw the negotiation about the recovery fund until the very last moment. We talked about disbursement and how this could be linked to the rule of law. We saw Poland and Hungary that for months were locking this unanimous decision, having a financial impact all around Europe. There is a blame that the rule of law was sacrificed when you had this big chance in front of you to put the blame on Hungary and Poland. What did you reply to that? And now a question towards the remaining ones. Was there a chance missed on the rule of law? Mrs. Varvitsiotti, allow me to reply to that. No, it was not a missed opportunity. No. On the contrary, it was an opportunity we did not miss. What does this mean? It created some confusion, and I believe that this is where these different interpretations come from. These misunderstandings, I would say, of this phenomenon. We had an agreement in July at the level of the heads of states and governments on the recovery fund. I would like to remind you that the summit, the EU summit, broke the record in duration. It lasted 4 days and nights. At the core of that were the discussions on the rule of law, and the final decision of the heads back then acknowledged the fact that there should be a conditionality on how the Commission would deal with the resources of conditionality vis-à-vis the rule of law. But when this political decision by the Council was put under the criticism of the normal procedure that is through the European Parliament, the European Parliament did not commit itself in no case by the fact that the heads of state and government agreed something throughout 4 days and nights, and they said, no, we have other ideas, we have other views, we need that, we need to do that in another way. We are here to decide about the budget, so we need different procedures. So the Commission, I'm saying so why? Because the Commission pays the price of this complicated procedure. The Commission was in need to converge to different but equally important parameters. That is, the political agreement on the one hand of the heads, and on the other hand, the quite clear vision of the European Parliament, which needed a tighter safety valve. What did we see? We saw this regulation when we proposed some decisions of the Commission that could freeze the disbursement of resources, and only through an opposite, a reverse qualified majority. How should I put it in Greek, says Vice President? So through only a reverse majority could be reversed by the Parliament. So we ended up with a classical model that the Commission will have the possibility to stop any payments. This is within the armory of the Commission. So the price we had to pay for that agreement was that we talked about a brake. The member state could pull up the brake and activate a 3-month procedure that it could express its doubts before the European Parliament. This was a compromise. Another compromise is that the opposition, instead of having a blocking of the Commission with an opposite majority, there was an approval by the Commission through normal majority. We can discuss here tonight, all we, the experts, about whether this is a sacrifice of the rule of law or not, in order for recovery to come to us. My interpretation as a person directly involved in all these procedures would be no. The reply is no. We had a new weapon in our hands. At any given moment, as a Commission, we can stop payments coming from the recovery fund. The break procedure opens a procedure of 3 months, discussions at the level of the European Council, but it doesn't stop the Commission. It does not stop the Commission. The Commission holds in its hands this decision to be made. And of course, there is the possibility for a member state to go before the court against the regulation, but also throughout this procedure, we can stop a bit, but in no case, I repeat, at least when it comes to me, I do not interpret this new regulation as a sacrifice to the benefit of growth. On the contrary, I would say that it is an opportunity we have now in our hands, which we did not have in the past. Okay. Any other comment by the remaining speakers? Was that an opportunity we missed? Mr. Skouris, please go first. I will agree to a large extent with what Mr. Schinas said. And let me mention that this development, that is the fact that we have an intense intervention of the European Council in what's going on in the state of play, what I alluded to before when it comes to the potential legislative function of the European Council, that it is a phenomenon that for sure limits the competencies of the Commission, or will have a tendency to do so, or will commit largely the discretion of the Commission for a later stage, which seems that it is obvious in the reaction that was presented by the European Parliament, the Commission, but also the European Parliament. On the other hand, though, even through these developments, and even through the critics that might be heard, there is right now an armory, a different armory, and this could be more effective compared to what we have implemented up to now, provided that the Commission shall insist on that, shall insist on its implementation. Thank you. Yes, ladies first, of course, ladies first, and then I will follow. So you have the floor, my lady.
Thank you. No, just 2 words. I think the word Mr. Schinas used quite often now when describing what has happened was the word compromise. And that's just what we always need. And that's typical for how the EU works. The compromise is fine. It's then only a small step forward. We would like to have a bigger step. The compromise is just a small step. So one thing we have to be aware of, that we always have to find compromises, and that is difficult. And the other question, and that is also in your question that you asked, is communication, because how is it communicated? And you asked, was it a failure? Was it you said, was it a missed opportunity? So that is the message that arrived at many people. They thought, well, they have negotiated 4 days and 4 nights, and in the end, it was a missed opportunity. So that is, both are sort of typical and problems of the EU. They always have to find compromises, and when they communicate, the message is often not seen as we would like it to be seen. Thank you.
If I may, please. Thank you. I am in favor of compromise, so I know pretty well how the EU moves, with compromise, through compromise, step by step, and how we have reached this impressive result of European integration. But the guarantees of rule of law are important when of compromise, when of bargaining and negotiation, when they are as a guarantee of those who does not agree, when imposed through the judiciary. What happens in this case? In this case, we link a political matter, by definition, which is the allocation of resources and budget, with a par excellence legal question, which is the guarantees of the rule of law. This is a hybrid form which you can tackle in a very difficult manner. What happened? In front of our eyes, at the level of the European Council, we saw a political tackling of the issue. This was managed by the European Council, by the heads of states and governments in an intergovernmental way. Then the European Parliament came and said, the European Council, having a political and intergovernmental manner, raises competencies from the Parliament, from the Commission, and from the Council of the Ministers, because the European Council, that is the summit, has no lawmaking competencies. Thus, we shift towards the legal level of the EU, that is the level of the EU approach and the community method, the so-called community method. Thus, we were brought to the result we all know. The big question now, is it a missed opportunity? Is it an opportunity we get? This will seem in practice. This, we can tell so from how the system will work. If we put pressure on Hungary and Poland through the carrot of resources, and if they limit down intervention and get the rule of law, this will be a success. If they get the resources, on the other hand, and if they continue violating the rule of law, it will be a failure. We shall see that in practice. But the negotiation, luckily or not, will continue. Why? Because the fiscal life of the EU does not stop here, nor does the European integration with this MFF or with the resources of the Recovery Fund. We have many other open questions. Hungary, Poland, Romania, Bulgaria, and all other countries which are outside the Eurozone and are suspect vis-a-vis the rule of law, transparency, etc. They will give their own weapons, which might start from European safety in the military sense of the word, up to the European ideology, meaning that we must be loyal to the principles like rule of law and democracy. Do you believe for the Vice President and the other ones might follow, do you believe that you have enough weapons in your hands to tackle this phenomena? Or do you feel that systems and the European Court, it takes much time to rule? Broadly speaking, do you have the mechanism that you would like to have in your hands?
Now, this question, a theoretical question we have been concerned with, but when it comes to the executive body of the European Union, that is the European Commission, I believe that what matters most is action rather than words. So deeds rather than words, not what we have, but how we can make the difference. And by witnessing how the Commission has handled these developments, I would like to share with you a personal thought, but I do believe that it mirrors our collective decision. So we were found with the Article 7 mechanism, which is burdensome. It is indeed the button with a nuclear bomb. It can give rise to extraordinary results, but it is extremely complicated when it comes to approval, activation, and de facto through decision-making procedures which take out its regulatory valid. So what did we manage to do in 2017 and 18 for Hungary and Poland? We managed to achieve a political procedure. Let us admit that. Article 7 is a political procedure. I believe I use the politically correct term, inherent value of improvement. So given that, I mean, if a country is under the Article 7 procedure, if you are a foreign investor, if you want to build or to invest or to purchase, you just have some second thought. So this is something which applies as a weapon, as it were. But what was proven much more efficient and effective, and we have repeatedly activated, are the infringement procedures. These infringement procedures provide us with some surgical instruments, as it were, allow us to step in exactly where the problem is. Mr. Skouris has witnessed many similar cases being brought before the court, but in the case of these infringement procedures before being brought before the court, there's a whole other set of mechanisms, and much has been achieved through the infringement procedures before ending up to the court. Now we do have the annual rule of law, the rule of law report, and this will be a test, a truth trial for each and every member state of the European Union. So this is expected to improve the situation. And now we also have the new regulation for the conditionalities, which is yet another weapon. So if the question is, are you satisfied with the instrument you have? My answer would be, yes, we are. But as rightly Mr. Venizelos has pointed out, we will see at the end, so a posteriori, when all these weapons will be activated, whether they will bear fruit or not. Do you have anything else to add? I am asking all the other speakers. Now, there are many I would like to ask you a question that pertains to the mass media, which is very close to my heart. There is a series of conspiracy theories and fake news of the past periods. I would like to ask you whether these may be dealt with from an institutional point of view, whether they erode the credibility of the European Union, and what can be done. We can start with you, Madam Nussberger.
Well, I just wanted to have a little addendum on what was said, because the fear I have when you talk about the effectiveness of these tools is that with rule of law, at a certain moment, it might be really too late. When you have, for example, with the judges in Poland, when you dismiss judges and then you replace them by others, then you have a real difficulty what you do with rule of law with the new judges, and how you can change them back. So that was just the thought I wanted to add. And now about mass media there as well. I mean, what we observe, I think it's just these days that we have the new rules on mass media in Hungary, that the financing of the last mass media that are understood to be free, that they have to stop. And that is, for me, a very important part of the whole picture, and that's why I found it very convincing that the Commission, when they wrote these rule of law reports, they integrated the media as well. So they had a holistic picture and took this issue also into account, because I think it all plays together. And just before I said, communicating about the EU is so central, and when you have no real voice in the member states explaining these compromises and these difficult procedures, but you have populist approaches, always criticizing, always saying something negative, the whole system is easily destabilized. So indeed, it's a very important part of the whole picture.
Anyone else? Mr. Skouris. Well, just a moment, please. What I would like to say is this. This is indeed an aggressive policy by specific governments in specific sectors. What have they attempted to manipulate or to restrict? Firstly, justice. They cannot tolerate an independent judiciary which will abide by the rules of the rule of law. And here, rightly, Mrs. Nussberger has pointed out that despite the sentences and convictions by the European Court of Justice and the Court of the Human Rights, they have met their objectives because those judges have been replaced or disciplinary measures have been taken against judges who have even referred some cases to the European courts. I mean, some cases are even unbelievable, I mean, and unprecedented. And the second sector, of course, in which such an aggressive policy was indeed the mass media. As a result, many of those media do have relinquished their voice. And thirdly, or are censored. And thirdly, is another sector greatly affected. That is what you touched upon, Mrs. Varviciotti, the fake news and the conspiracy theories, which find breeding ground not only in these member states, but in other states as well. But it's not by accident that those member states often are the breeding ground for phenomena that need to be contrasted and curbed. So this is an assault against, well, let me say the institutions of the rule of law, but in fact, this is the abuse perpetrated by a democratically elected government, which has recourse to a pre-election program with a view to enforcing measures that are absolutely in contrast with the rule of law. And indeed, there is a tendency, or rather a resolve, to have recourse to democracy or to the democratic principle, to enforce obligations and restrictions that are usually enforced on minorities, as Mr. Venizelos has pointed out. But minorities need to be safeguarded and protected against the majorities. Now, this is not true in those member states. That is to say, says the speaker, the fact that there is a majority post-election means that actually they feel as if they were entitled to do anything they wish, which is not the case. I would like Mrs. Varviciotti to add this, if I correctly understand your question. Apart from the aspects touched upon by Mrs. Nussberger and Mr. Skouris, there's another issue here. The fake news and misguiding and misguidance of social media, right? So if to my understanding, you're asking whether the rule of law applies to the internet of Europe. So if our perception vis-a-vis the rule of law is effectively enforced on the internet, which is a very challenging question because it is not a matter of jurisdiction. I mean, the institutions of the European Union and the Council of Europe believe of having a jurisdiction, of having the competence. There are important jurisprudence, case law of the Court of the Human Rights when it comes to the right to damage, the freedom of speech, the specific restrictions, and there is similar case law of the CGU. However, you may see that no matter how powerful a legal order may be, it cannot actually impose itself on the internet. Not even the American one or the Supreme Court of the US rulings or the legal order of the European Union, not even the European Convention of Human Rights legal order, not even the legal order of Australia that asked intellectual property rights from Google, and Google said, okay, I just cancel you. I block you in Australia in order to spare any further problems. And so here, currently, Facebook itself has ended up setting up its own Supreme Court, I mean, in brackets, with high-profile personalities they have opted for in order to safeguard what they claim to be the speech pluralism in its own internet jurisdiction. And this is a challenging of sovereignty of jurisdiction of all state or similar to state, because of course the European Union is not a state, but have similar institutions, similar aspects to that of a state. So all that real legal orders are subject to great pressure because of the dynamics of a universal cybersphere, which indeed goes beyond and permeates legal orders. So, Mr. Schinas, how are we supposed to cope with that? I mean, if we cannot address that and address all the legal gaps from an institutional perspective, what can we do? Now, look, in December, my colleagues rolled out a framework for platforms, simply put, because of course we are running out of time, that could be the European model for the management of digital technology in Europe. So some answers are provided, which of course have a different answer in the US and for questions not even raised in China. So this is under discussion right now. It will shortly be discussed in before the Commission and the Parliament. And we are discussing the rules, because certainly the internet is not the herald of some decades ago. We know, and the platforms know very well where the algorithms are. They know very well how to save on taxes, and they know much, much more than that. But as long as they operate in Europe, they need to abide by our law, safeguarding privacy with the right to oblivion. It's not by accident that, of course, all the platforms employ many, many thousands of people here in Europe in order to make sure that they abide by the court's decisions, the court's rulings. So I'm optimistic when it comes to these platforms. We are witnessing the initial stages of a digital governance European model. It will be very interesting in view of the latest development of artificial intelligence, which is not of the future. It's here to stay. So Europe needs to recognize that. The previous European elections were the first time in which we saw that. We have a renewed cybersecurity approach. So we left behind the age of the innocence, and we are getting mature.
A final question from our speakers. What are the lessons learned by this crisis that we faced on the rule of law in Poland and Hungary, and how can we use it for the future, for future enlargements? Will there be a stricter EU when it comes to future enlargements in Western Balkans? Mr. Schinas, let me go first. I'm pretty sure that my co-speakers will have some brilliant ideas about that. So, I have 30 years of expertise in EU politics. I remember pretty well the different procedures before the accession, the pre-accession procedures that led us to the big bang of 2004. I remember as if it was yesterday. I remember a beauty contest in the past of the heads of states and governments at the level of the EU visiting the candidate countries, telling them, no worries, you are ante portas. Everything will be easy, everything will happen, everything will be better, we will accelerate, we'll speed up, but please pay attention. This beauty contest was not only coming from one political family, this was coming from all political families. I remember Gerhard Schröder, back then as the Chancellor, and José María Aznar and Jacques Chirac telling the same things. So let us not fool ourselves that this procedure back then, our concern or our rush to reconciliate history to geography in Europe in a speedy way would rectify all problems. But it was a necessary procedure. It was a necessary procedure to follow. That is, this historic endeavor of the big enlargement was not an erroneous step to take, was the good decision. But it led to today's concerns. It led to some flaws that should have been solved before the accession, and these had to be solved within the EU family. It also led to empowering some forces at the political spectrum of these countries that want to convince their societies that Brussels is a new Moscow, and both left-wise and right-wise. These are matters that we should tackle within the EU family, but I repeat, these are not matters that should make us repeal the historic character of this big enlargement of the EU. Having the weapons and the means of today, I believe that we can rectify all problems in the long run. Thank you. So will you be stricter? Because we need to avoid what you have just described, that is the way of the past, the enlargement that they did in the past. Maybe in the new enlargement, wherever it takes place, we can avoid such a thing. Have no doubt about it. Have no doubt that the next enlargement, wherever or whenever this will take place, it will not have the same historic character of the years after the collapse of the Berlin Wall. It will be integrated into another historic era with developments that will come. But I think that the accession procedure, especially following the change of the rules, will be stricter and more demanding. Would you like to add something? What about the other speakers? Because there must be some mechanisms, if I'm not wrong. If I may, because I remember that era back then, after the fall of the Berlin Wall, not that intensely as Mr. Schinas, but I lived the enlargement period being at the court. I would like to tell you the following, for sure. For sure, one might wonder, back then, shouldn't we take more measures? Shouldn't we demonstrate more attention? I'm not sure. I'm not certain about it. I believe that the enlargement was inevitable, and I would say something we wished for back then in that period. Mr. Schinas reminded to us the fall of the wall and the developments in Eastern Europe back then. So one should think of the following. Let us imagine what would be the state of play today following the developments in some countries if these countries were not member states of the EU. Would they have a better fate when it comes to justice in Hungary and Poland, let's say? I'm certain that the reply to that is no, because no matter what happens, no matter how many other reactions by certain governments, and of course, I'm talking about measures taken and measures that we abolish, of course, it is better to be a part of a family and be thus obliged in any case to justify your actions, to respect accountability or justify what cannot be justified, compared to being outside the EU family with the possibility to impose stricter restrictions compared to what happens within a family having a participation to the EU Council, the European Parliament, the European Commission. In other words, I want to say that we can be critical against all cases. It's good to take measures against any violations against the rule of law, but I believe that things could be even worse, Yes, it was a historic decision. This is not put in doubt. But what were the lessons learned? And how can we use that for a future enlargement? Yes, always we must be very cautious. The EU institutions should be very cautious during enlargements. But you know what? As Mr. Schinas said, there has been a beauty contest when it comes to the member states of the EU. But there was also another beauty contest coming from the candidate member states. That is, there was no unilateral beauty contest, there were multilateral beauty contests, and promises given back then did not always abide by the real situation, the real state of play, but I'm afraid that this was also inevitable. Of course, you know what? Even the enlargement towards the Western Balkans may not be under the form of the enlargement in 2004, which was another type of a procedure of another type and another development. Well, Mr. Venizelos, if I may, a comment, please, and then give the floor to the lady of the company to call it a day. Now, when I started my ministerial experience, Europe had 12 members. I remember that when we organized the summit of Corfu with Andreas Papandreou and Jacques Delors, we were the hosts of 12 heads of states and governments. And then we signed the agreement of the enlargement of Europe of 15 or 16 if Norway did not reject its accession for the second time. I remember that Greece and Cyprus became members of the EU family for political reasons mainly, not under strict development criteria. That is, there was a voluntaristic feature back then. In this sense, the whole European integration seems to hide some features of intense voluntarism throughout the European integration process and throughout the process of the monetary union. We have a problem of two circles. There is the circle of the Eurozone and the circle of the member states which are not members of the Eurozone. And then there is another important problem of strategic dilemmas when it comes to European safety policy and European foreign affairs. The same states, the states of the former Central Eastern Europe, have a decisive role to play. And now, since the EU will be invited to reply to big dilemmas, whether there will be a reconstruction of the West, will there be a new strategic notion of the West, how can we revive the axis of cooperation between the EU and the US, what will happen against China, what will happen vis-a-vis Russia, questions which are very specific and thorny vis-a-vis the trade agreement between the EU and China, vis-a-vis the Nord Stream 2 and the completion of the pipeline to transfer natural gas from Russia, and so on and so forth. We must take into account that this bigger Europe of 27, even through contradictions, has some assets as well. It's not just a burden that we are carrying due to the rule of law. And a final say by the lady of the company, Mrs. Nürnberger, because we're out of time. Please, you have the floor.
Yeah, thank you very much. Just one sentence. I think Europe in this way resembles really a family. And we, even the old members of the family, can do something really unexpected. So it's not only the new members, let's say the cousins, it's also the brothers and sisters. And we all remember the last elections in France, and Le Pen was in the last round. So even our old democracies can have a political turn that is really unexpected. I think we have learned a lot. We had the Copenhagen criteria, and now we have the new procedure that applies to all. So we have learned a lot, and we should stretch out our hands for the cousins in the Balkans and for the others, and find a way to take them in our European family. Thank you.
I would like to deeply thank you all for your participation. I would like to deeply thank all our speakers, Mrs. Newsberger, Mrs. Kouris, Mr. Venizelos, the Vice President of the European Commission, Mrs. Schinas, and of course, Her Excellency, the President of the Hellenic Republic. And of course, Konrad-Adenauer-Stiftung, the e-Kyklos Ideon, the Circle of Ideas, and of course, all the organizers of this unique event. And I would like to wish you all good night, and I hope that you got some replies to your thorny questions and a bit of optimistic tone that the European Commission works towards this direction, that is for a better management of rule of law in the future. Thank you all. Thank you so much. Thank you. Thank you. Bye-bye and take care. Thank you.